Hello, everybody. Let me shut my fan off, my biggest fan. Hello, everybody. Welcome back. My name is John. This is my channel, your Renaissance Man. It is Thursday, August 22nd, 2024. This is huge news for the Second Amendment. And this isn't clickbait, my friends. This is the real deal. Machine guns are legal to possess, according to John W. Brooms, the Honorable John W. Brooms of United States District Court Judge in the District of Kansas. Yes. Case number 23-10047-JWB. I'm going to put it up on the screen too for you, those of you for it's easier to read versus listen to me. Before I get to all that, first I want to thank our subscribers. You guys are awesome. Thank you very much. If you haven't subscribed yet and you're willing to do so, it'd be greatly appreciated. That's what helps us out the most as a new channel is subscribers. If you're subscribed already, if you can continue to support us by either like, commenting, or sharing. So yeah, so it is Tamori Morgan, Tamori Morgan versus the United States. And he was charged with possession of machine guns. And like I said, the case number is 23-10047-JWB. And I'll flash that on the screen. So the matter is before the court on defendant's motion to dismiss based on Second Amendment grounds. A response and reply have been filed, and the court held a hearing to establish additional facts about the weapons charged. The motion is thus ripe for review. The court finds the Second Amendment applies to the weapons charged because they are bearable arms within the original meaning of the amendment. The court further finds that the government has failed to establish that this nation's history of gun regulation justifies the application of 18 U.S.C. 922-0 to defendant. The court therefore grants the motion to dismiss. Holy crap. Defendant Tamori Morgan is charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. Specifically, the defendant is charged with possessing an Anderson Manufacturing Model AM-15 300 caliber machine gun and machine gun conversion device. It was established at the hearing that the conversion device is a so-called Glock switch, which also allows a Glock Model 33 357 SIG caliber firearm to fire as an automatic weapon. So what's encouraging about that is we're talking about stuff that would generally be considered I would say a genuine machine gun, not stuff that increases rate of fire by definition, like FRTs, binary triggers, stuff, bump stock stuff that we've been fighting recently. This is more to the true definition of a machine gun. So I'm guessing it's an AR-15 derivative, and 300 Blackout was the one, the Anderson Manufacturing one, then the other one's a Glock 33 with a switch on it. So yeah. So I mean, they cite Bruin, they cite Heller beautifully. Definitely go check it out and read the whole thing for yourself if you understand this verbiage. I follow Mark Smith quite a bit at Four Boxes Diner, and as he says, he wants you to be the smartest person in the room, and I've learned a lot from him about this topic as far as how to read these things in the Second Amendment and how it applies on a constitutional level. So the government was pretty much trying to say that there were, unusual, dangerous type stuff, but then the court says, court cited it beautifully. Where is it? I got to find it real quick. They cited that it's not unusual because the NFA currently has, where's the number? I want to be exact on this. Where is it? Oh my God, this is so beautiful. Okay. Moreover, to the extent Second Amendment would allow weapons to be prohibited solely on the basis they are dangerous and unusual or highly unusual in society at large. Bruin 597 U.S. at 47. As the government suggests, the government has not made the showing here. As defendant points out, there are over 740,000 legally registered machine guns in the United States with the ATF. Machine guns have been in existence for well over a century, while the federal government has regulated transfer and possession of such weapons since the passage of the National Firearms Act in 1934. and it did not outright prohibit possession of machine guns until the passage of Firearms Owners Protection Act in 1986. Even then, the law did not prohibit the possession of all machine guns. Rather, merely prohibits possession of machine guns that were not lawfully possessed of the date that prohibition went into effect in 1986. Thus, even today, it is perfectly legal for a person to possess who has not been divested of their firearm rights under some other provision of law to acquire and possess a machine gun. So long as it was lawfully possessed, someone before the relevant date in 1986, and so long as he complies with the NFA requirements to obtain and possess the weapon, in that sense, machine guns are not unusual. Oh my God, is that beautiful? Well done. Well done, Judge. In that sense, machine guns are not unusual. The government fails to address these facts and thus fails to meet its burden to demonstrate that the possession of this types of weapons at issue in this case are lawfully prohibited under the Second Amendment. Holy man. That's awesome. That's awesome. Like I said, I follow Mark Smith quite a bit, the Four Boxes Diner, and I firmly believe in what he says, where he talks about that you got to celebrate every little victory because everyone is pulling one stone out of a wall, and once we pull enough of those stones out, the wall's going to crumble. And this is the start of it. This is the beginning of the end. For the NFA. Yeah, holy crap. This is huge. Granted, this isn't an instant victory where everybody's going to be able to buy machine guns at their local gun store tomorrow. Believe me. But this is the start of that. Yeah, holy smokes. This is huge. I mean, of course, and it's going to be appealed and all that good stuff, but this is the start of it. Yeah, John W. Brooms, United States District Judge, August 21st, 2024. Yeah, this is huge, everybody. Share this. Get out the good word. This is a big one. You know, we just got the bump stock one, which I understand a lot. I understand a lot of people's argument why, you know, it's such a device that why do we want to fight for something like that, you know, but that's not the reason we're fighting for it. We're not fighting for it because of its practicality. We're fighting for it because it's an infringement on the Second Amendment. Because every time they get to sink their teeth into it, they go a little deeper. And this is a sign we're kicking their teeth out. Wow. Anyways, I had to get that out quick. This is great news. Share it with your friends, anybody. We're a new channel. Do what you can to help us out. It'd be greatly appreciated. So thank you again for watching. Hope you guys have a great day, and God bless you.